Hello, everybody. Welcome to another session of Lunch and Learn with GEO. I'm GEO, formerly known as George Bellis, and we try to do this every other week with my schedule, when my schedule allows, and try to focus on tech issues for law firms and for the courtroom. We've got an interesting topic today. We're going to talk about using video at trial. We have a disclaimer. We're lawyers. I have to give a disclaimer, right? And we're recording. So I also try to keep an open mic if anybody wants to, but please don't abuse it. Whistle for your dog or anything like that. But be careful about what we say because we are recording. If you have questions, use the Zoom chat box. I will post the questions to Sean. If you post to social, this is the hashtag I'd like you to use. The next webinar that we have scheduled as of right now, although that may change, we may have something on the 14th. A nationally known speaker on marketing, Annette Chody, is going to give us a talk on 5 steps to grow your law firm online. You're going to get free, if you're a member of the NWSBA, you're going to get free CLE credit here. I'll give you information on how to apply for that. If you're not a member of the NWSBA, here's the plug, shameless plug. Join now. We have a lot of events coming up, including the golf outing on September 21st. We're here today, as I try to tell everybody all the time. We're trying to increase your tech competence, and they're not new so much anymore. They're 2015. In doing CLE, we have to understand the benefits and risks associated with technology. And all aspects of e-discovery are important for everybody to know. Everybody knows that I'm an e-discovery fan. So with that, I am going to turn it over to Sean. And I'm going to stop my screen from sharing and say, hello, Sean, and welcome back. This is your second or third time presenting? Second. Okay, well, let's hope it's not your last.
Let's hope not. So,
right.
Everyone, I see some familiar faces, some good friends. It's good to see everyone. Actually, the first person that's going to speak is Doug Blanchard. He actually is with Lexitas, and he's going to kind of take you through the current technology scheme and what's being used in the courtroom. And then I will pick up from there and give you a couple tidbits that I've learned over my 17-year career or 16-year career, however long it is. So Doug, I'm going to operate the PowerPoint for you, but I'll let you pick it up.
Sure. Well, great. I appreciate it. Thanks, Gio and Sean, for asking us to get involved today. We've worked with the bar quite a bit, and this is our second or third presentation. Many of you, hopefully some of you, were with us right after the pandemic started. We presented well over 50 CLEs for attorneys understand Zoom, remote depositions, and now that's just become second nature to us. So I think it's a great indication of how technology is changing our industry. And it's a matter of how we evolve with that and how we take advantage of some opportunities. So my role here today is just kind of giving an overview of the evolution of technology at trial over the last several years, kind of understanding what's happening and where it's going. And then Sean's got some wonderful content that I think will make it all make sense for you. So if we get started here, this is just a quick overview. You think back to flip charts, and that was, pretty much the standard for doing any type of courtroom presentations. And again, not that long ago that really was the standard. And then went to the overhead projectors or the Elmos. And even though I've been in this industry for quite a long time, had no idea what an Elmo thing was, and realized that it was not some character from Sesame Street, but actually a fairly sophisticated piece of equipment at one point. But that's been the standards, but you really don't see this anymore. And I think that's reflective of where we are as an industry and also as a society, as that technology pretty much drives everything. So the next slide shows where I think we're currently at, and that is being able to bring technology to the courtroom and use the iPad, which I think many of you do, or even the large whiteboards. Technology is something that people expect. And if you're using the flip charts, I think that doesn't help a lot with the perception of what the firm is doing. One thing I want to cover very briefly and go over is the amount of generations that make up the jury pools now. And, or I'm sorry, one thing too, with the attorneys, again, that's typically been a situation for you to shine and you know, practice all of your skills, but the technology is not backing that up. That does become a problem. So a quick overview of the generational issue. The greatest generation is pretty much out of the jury pool at this point. But again, they brought a very straightforward, fact-based type of approach to it. The baby boomers are currently kind of evolving through that. I am one of them, and I'm not far from retirement, thankfully. So I'm excited about that. But then going forward into the newer generations, Gen X is kind of the lost generation. So they were the ones that were the latchkey kids, were very self-efficient and so forth. When you go into the millennials and especially Gen Z or iGen, whoever you call that, they're native. I mean, they grow up from the cradle with this technology, and it's expected. It's part of what they do. They don't find it intimidating. It's just, if you're not doing it, you know, I've had my 6-year-old grandson look cross-eyed at me going, "Grandpa, how come you don't understand this?" I said, "Because I'm old." But again, I think that's something that we're definitely facing in dealing with the technology in the courtroom, is having a very sophisticated approach to that. So that, I think, is a quick overview. Something to keep in mind as far as jury's attention span. You know, we have lots of studies about this, and we can advance that through. I think you've obviously understood this practicing, but it's not so much what they hear, and it's not so much what is said, but it's how they actually process it and get involved with it. It's entertainment, and I think the society's been tainted a little bit with, like CSI, some of those programs where people think that jury trials wrap up in an hour with commercials. And that's just not how it works. It's a long process, and a lot of effort goes into it. So I appreciate the opportunity to work with you a little bit this morning, and Sean will take it from here and enjoy the day. I appreciate it, folks.
I also want to remind everybody what a big supporter of the bar Lexitas is. They are regular advertisers and supporters of us in all our events. So thank you, Doug, and thank you for being here.
Sure, my pleasure. Thanks.
Doug, again, I appreciate you being here. And although I consider myself a member of Gen X, I don't want to think that I'm a lost generation. And I think a few people on this call are. So everyone, again, my name is Sean Driscoll. I'm actually just started my own law firm coming January 3rd of this past year called Driscoll Law Group. A little bit background on me is I was a partner at Clifford Law Offices for 6 or 7 years. And before that, I was an associate there. And before that, I was a law clerk there. And before that, I clerked for the late Justice Mike Murphy. My practice while I was at Clifford primarily focused on transportation, trucking. I still work with them on most of their railroad work as well. In particular, I was the first person to try Amtrak 501 back in federal court in Tacoma, Washington, back in 2019. And now I'm working with them on the Montana derailment in Joplin, Montana. But also part of my practice is I would try medical malpractice cases as part of their trial team. So some of the cases that would be worked up by other attorneys, I had the fortune of picking up their reins and then trying those cases. So what I've tried to put together here is a little kind of concept of how I approach when I'm looking at a case from the beginning. And to echo what Doug said is I truly believe we are storytellers, all right? And one of the ways we can tell our story about what our clients have gone through is by video, right? And to Doug's point that 70% of, I guess it would be Gen Z or millennials retain what they see by vision. Okay. You know, it's interesting enough that he makes that comment about future jury pools, right? I look at my 4-year-old daughter, Rory. She's using an iPad right now and going through it and operating it better than I can. And she's 4 years old. So when I look at her doing that, I'm thinking, oh my God, I've got to become more savvy with tech. And when George asked me to do these, it's obviously tech focus. And one of the things that I see lawyers not utilizing enough at trial is video. So that's why I'm trying to kind of set out of what this CLE is for. So what does it mean to be a storyteller? Storytellers, attorneys are responsible for telling our client's story and managing all the evidence that appears at trial. And this is one of the main things that we need to think about is have a game plan early. I know that Kristen's on here and Jim's on here doing med mal cases. You know, Jim and I have had many conversations about which depths you video and which ones you don't. My perspective is I like taking defendants' depths via video. I don't really care about the experts' depths via video. They're hired guns. And we'll get into why I take defendant doctors' depths or other defendants via video in a minute. But one of the things you need to do early on is you need to have a game plan on what kind of case you're going to do and which depths you're going to take video. Now, unfortunately, what you're going to do is you're going to choose not to take a depth, or you're not going to videotape a depth. And then after the depth, you're going to think, damn it, I should have videotaped that depth. It happens to all of us in our practice, and I'll get into a way that maybe we can avoid that, because being a practitioner, videotaping depths is very expensive. You know, being my own, shop now, and I've got my wife as my partner, you think about costs when litigating a case. So what is the method of taking depositions? I am always shocked about how many people don't read the rules. All right. So what I've put into this presentation and what will be available later on is Rule 206, which is the method of taking depositions. Okay. So you've got 206.2, which is the audio-visual recording being used. And then you've got Rule 206F. All right. And I think that this is really important for people to know and use. And Doug may not be happy what I say here, but I think it's something everyone needs to know. And actually, Mr. Coogan and I on this CLE have had this discussion numerous times. If you read the rule, and I've highlighted here, the testimony shall be taken stenographically, by sound recording device, by audio-visual recording device, or a combination of all three. So what a lot of people don't know is you don't actually need a stenographer there at the time. As long as you have a notary and the video, you can take the dep. So the notice must so advise all parties of the deposition. The notice of intent must likewise be served upon all the parties with a reasonable time. And the notice shall contain the name of the recording operator. And the notice is given that a deposition will be recorded by audio-visual device, and you need a notary. But I know that there are some attorneys out there that just do the visual recording, and then if they need the transcript later, they'll actually have it typed up. All right. So there are ways to manage costs here. So what I've provided here also is just a general copy of the notice of videotape discovery depositions that we have here. This is one that I used at Clifford Law Offices. And when I was preparing this this presentation, I realized that this particular notice was not done by Lexitas. So I scribbled it out and put Lexitas in there. But this is typically what you need. You've got to provide the notice, and you've got to provide that it's going to be videotaped. Recently, I was in a deposition on a big construction case. We were doing it via Zoom, and it was a regular notice of deposition. And I knew that the witness was not going to be good for me. So I objected in the beginning of the dep that the notice wasn't proper for videotape, and they stopped videotaping the dep. It's something you should be aware of. It's something you should look for. A little practice tip that we have there. So why do I videotape deps? And why do I videotape defendant steps? The reason why I do it is because of Supreme Court Rule 212A2, as well as the Illinois Rule of Evidence 801D2. Supreme Court Rule 212A2 specifically provides that depositions may be used as a formal statement made by a party or its agent as admissions. So one of the issues that I think most plaintiffs' attorneys are struggling with is whether or not you call your defendant doctor in your case in chief. You know, there's two schools of thought. One is, do you allow a defendant doctor or even a defendant driver in a trucking case to educate the jury in your case in chief, right? And then the question is do you allow the defendant then to do a direct exam of their defendant, either defendant doctor or anyone else in your case in chief? The true question is do you want that doctor or that defendant to educate the jury when you're putting on your case? A way to avoid that, but still get in the admissions is through Supreme Court Rule 212, right? So in doing that, if you have good video and you know the story you're going to tell in the beginning, you can lay out what you want to put in through video in your case in chief without even calling the defendant. This is one of, and here as a practical point, we'll get more to the substance of the rule in a minute, is you really got to struggle is, did I get what I want out of the doc and the defendant dep, right? So the way I've used this in medical malpractice cases is if I've got standard of care deviations and I've got it on video, I will just play those clips. Or did you do X? Did you do Y? Or in particular, in a trucking case, you know, one of the issues that I got right now in a case is, did you do an inspection before you left the facility? And I've got on tape this guy saying no, it's an admission. So when I'm on trial, I'm going to play that clip. And then I'm going to call my expert right after I'm saying, if the jury heard in video the defendant say that he didn't do an inspection before he left the facility, was that a negligent act? Or was that, or is that appropriate? No. And then he's going to give the opinion. So it allows you to line up your trial where you're like, okay, I can put these clips in that are the admissions or statements that I want, and I can immediately call my expert and refocus on those admissions. And that's what Supreme Court Rule 212 does, and it allows you to do. And 801D2 allows you to do. It also streamlines your case, and it doesn't allow the defendants to educate a jury in your case in chief. I think it's a very underrated and important thing to do.
I cannot agree with you more here, Sean, because if you just take the excerpts and you throw them in as admissions separately from everything else, and especially if it's by video, it's very effective. We did that. We did that in the last case.
Yeah, and I did it in my, I tried one case right before the pandemic. It was February of 2020. We tried, it was a medical malpractice case. We ended up doing a high-low at the end. We did it in Amtrak 501, and we had it loaded for my last trial, which settled while we were picking a jury. But here's the thing, too, is you're not playing the whole depth. You're playing 10 minutes. To Doug's point, you're playing snippets and you want to keep their attention. So you don't want to, 10, maybe 15 minutes, depending on what it is or who it is, but you gotta be concise. Okay. So in my deck here, I've got some case law that I've used. I've actually put in briefs where it says specifically, statements made by a party during a deposition are also admissible as an exception to the rule, excluding hearsay when introduced by a party opponent. Okay. And then when you go to 801D, it specifically says what you're looking for here. And it's incredibly broad. So if you've got a safety director, if you've got an actual named defendant or anyone, it's a statement by a party's agent or servant concerning a matter within the scope of their agency or employment made during the existence of the relationship. I can't tell you how many times I don't care what my defendant truck driver says in the step. Maybe I get a couple snippets, but I take their safety director because I go, if your driver didn't do this, was that a violation of your safety rule? Yes. And you just rip through that. And it's 10 to 15 questions. It's 10 minutes of tape and you play it. So I think that is very crucial. I'm surprised actually how many people don't know 212 and 801 D2 that they can do that under the rules. I've said it to other practitioners, like, what are you talking about? Just playing the video. I can't do that. I'm like, you absolutely can. And if you don't videotape it and you've got, a transcript, do it via transcript, just get a great reader. So similarly with Rule 30 for the federal rules of civil procedure, we dealt a lot of this with 501 back in Tacoma as relates to whether or not they admitted liability and causation and damages. But the rule is very similar. The notice must state the method of recording. Testimony may be recorded audio, visual, or stenographic means. A party may arrange to transcribe the deposition. The parties may stipulate that the deposition may be taken by phone or other remote means. So if you're recording someone on the phone and you've got their audio but not their video, that's great too. The rule allows you to utilize that. Here, if you look at how it can be used, you should go, look no further than, again, Rule 801, but also Rule 32, using depositions in court proceedings. Deposition of an adverse party may be used as substantive evidence to prove or disprove a fact. All right? Substantive evidence. This isn't impeachment. It's nothing like that. It's actual substantive evidence. And if you're in federal court and you take a grant, that guy should never be, or that girl should never be on the stand in your case in chief. So before we get into some of the kind of video that I've used and to show you some things, I want to, do a quick summary of reasons to take the video depth. One is video impeachment. Early on in my career, I thought video impeachment was very important. We videotaped all the experts. And sometimes it's convoluted, and you do it too much, it loses its effectiveness. Video impeachment should be used sparingly. You shouldn't, when you're at trial, shouldn't have 25 clips ready to impeach, unless it's just crushing impeachment. One of the other reasons why I like to use video impeachment is controlling defense counsel or plaintiff's counsel's objections. There is a particular defense attorney out west who will remain nameless, who loves to just do speaking objections. On every case I have with him now, I will videotape the defendant's step solely for the purpose. If I ever have to bring a motion for protective order, I will literally give the video to the judge. And the best part is you can clip it too. You can just do clips. One of the other reasons why you do it is evaluating a witness. I can't tell you how many times I have taken a defendant doctor's step and I've said, hey, I would need you to watch, someone in my firm when I was at Clifford, or even just a colleague now, say, here's the video. Tell me what you think of this guy. If your plaintiff or defendant dies and you want to perpetuate the testimony, you do it for that. A picture is worth 1,000 words. A video is worth 1,000 words plus the testimony. And I'm going to show you a clip of that. It helps with trial preparation. The other thing with video, witnesses tend to be on their best behavior. And then again, using video depositions under Rule 212 and 801. So video impeachment. Everyone knows now, if you've been on social media, and now that I've started my own firm, I'm looking at doing TikTok and everything else. There aren't enough clips of of Amber Heard being impeached or videos corresponding. I mean, you can't get off of that. So one of the reasons why you do it is for that. The other is evaluating a witness, and body language and timing can be very telling. So I'm going to play you this clip. For background, the issue in this is the amount of blood loss during a procedure. And one of the defenses in this case is there was during a procedure where a patient lost 800 cc's of blood. This particular doctor had 3 opportunities to correct the note and did not do that. So I took this deposition, and here is one of the doctors, and you can judge for yourself on his body language. The other thing he does in this, what I love, is he asks to have the question read back. I love when a deponent does that on video, because if you get an opportunity to impeach him on that and they've had it back in the video dep and you keep it in the clip, it's incredibly powerful. So here's the clip. It's about 35 seconds or so.
You had an opportunity to review the option. I did back in 5 days.
Hopefully you can hear it.
True. I did. I mean, that is stitch. I don't know. You've seen the audit trail. I have indicated 800.
Can everyone hear it?
No,
Okay, hold on. Let's see if I can try it again. Can you hear it now?
Then your handwritten instruction.
Now?
Short. It's indicated as yes.
Yeah, I'm pumping it up.
Opportunities to change that for correct and fair.
start it again. Start it again.
The other thing I would tell you, everyone, to do is when using technology in court, sometimes things go bad. And when they go bad, you need to stay calm and not worry about it. Because it happens to everyone. It will happen to me again. And we will figure it out.
Then you could tell the jury that you're a Luddite,
Yeah. Perfect, right?
like Marshall Dickler.
Exactly. I love it. So we're just going to close this down and we're going to start it back up and hopefully it will work.
You know, we've had all kinds of experiences with replaying video on Zoom broadcasts. It's not that easy to do.
No, it's so let's see what we can do here. We will see if we can get this. And what I may do is I may just do it in not the presentation format. And let's see if I can load it up here, or we can play it when we're not doing the presentation form. Can you see that?
Yes.
Well, you had an opportunity to review. Your
How about now? Can you hear it?
I did. Back in
All right.
5 days. Correct. Yes. And you reviewed it. True. I did. You made edits, didn't you? I don't recall. Have you seen the audit trail? I have not. You indicated 800 in our report, didn't you? I did. And then on the anesthesia record, there's indicated 800. True. True. And then on your handwritten surgical note, your short note, it's indicated 800, isn't it? Yes. So you had 3 opportunities to change that for correct and fair. Well, that's based on anesthesia's estimate. You had an opportunity to change or correct it. True. I had an opportunity to change it. Yes. And you didn't. That is correct. And you know, like everyone here knows, you want medical records to be as complete and accurate as they can be, correct? Because other physicians are going to rely on those medical records. True. True. And in particular with this case, when there was an ischemic arm, you knew that other physicians would be relying on your medical records, correct?
Check false for speculation.
I'm sorry, the question again? Can I get back, man? Thank you.
Right, in particular with this case, when there was an ischemic arm, you knew that other physicians would be relying on more medical records.
Yes.
So the issue in this case was whether or not there was 800 cc's of blood loss. Now, they've been fighting it the entire time of the case, but as you can see, he spent a good 45 seconds, maybe more, more than that, thinking about his answer. Because he knew if he says it's not important, he drops himself into a jam. And if he says it's not, they're going to have a hard time getting around that 800. But if you get to play that clip in front of a jury as a statement, people now understand that him not changing that medical record is a very important issue, and he dwelled on it for a long time. I'm going to reload this deck so we can continue with the slideshow. Let's do this. Here's another video, and hopefully it will work for us. So one other thing I think is important is getting video from body cam. If you have any cases in the city of Chicago and there's a pullover or an accident, you need to get body cam. If you're not getting body cam and you know about the accident within 6 months and you're not doing a FOIA, it's a mistake. This is a body cam footage of an actual Chicago police officer that struck and hit my lady while she was walking her dog early in the morning while he was backing out. And the reason why this video is important is because in his deposition, he testified that he didn't do anything wrong, and he looked both ways before, or he testified it was not his fault, and he looked both ways. So if we play the video.
I'm at the airport. I was backing out of my driveway and I hit her because she was walking by and checked out my blind spots.
So on his own video camera, he's talking to his buddies and he's saying, I didn't check my blind spots. In this case, we had the video. The defense attorney must not have viewed the video or showed it to her client and allow him to testify that he checked all of his blind spots. So again, but this is to Doug's point about CSI. We have access to get all this information. And if you have a jury pool now that is getting more progressive where they want this type of things, in an auto case, you can get these things. And it's very telling as long as it helps you, right?
And we've done webinars on how to get the evidence collected during discovery.
So going back to the technology that Doug first kind of hit on before, how to present via trial pad. Two things I would say about this. If you're using trial pad, use it on a smaller auto case first and get comfortable with it. The first time I did it was with a medical malpractice case, and I learned the hard way. I just wasn't proficient enough with it, and halfway through the trial, they kind of scrapped it and went back to the other method of presenting. So be proficient with it. It has the multimedia tab, I think, is very effective. I'm going to go through some of the formats which you should use for video, which is probably the most adapted. I also would never try to edit a video on trial pad. I don't know if other people have experience doing it, but I find it to be incredibly difficult to do. If you're going to use a video, edit it before you upload it on trial pad. Also, video impeachment on trial pad, doing that, I would do it a different method. I think sometimes, especially if you're doing a Bluetooth, unless you're hardwired in, it can cause problems. So what multimedia players should you use? There's the VLC, which is Video LAN Client Media Player. It's free and an open source cross-platform. It supports most devices. I think it's one of the easiest things to do. What I've provided in here are the various types of video formats that I can use. You know, if you're not tech savvy, it's not hard to download the VCL onto your platform and use it. Most of them you can do. And how you do it on your desktop is, if you've got the VCL on your desktop, just take whatever video file and drop it into the icon, and it should play it for you. So finally, what I want to talk about is the use of animations with photos. So one of the issues that we were confronted with in 501 is describing where our clients were and what evidence we could and could not get in for damage purposes at trial. At the very end, Amtrak kind of admitted liability, and there was a dispute as relates to causation and damages, and it was being governed under, obviously, the state of Washington law, which was a substantive law in federal court. We were actually in the Western District, which was one of the more conservative districts. However, I'll tell you that I think the judge out there gave me a very fair trial, although he allowed an instruction while the jury was out that the verdict would not be taxable. Otherwise, he was fair. So what we struggled with was trying to get as much we could of the scene in. So this next slide is the aerial view that we got in of the scene. So if you have any major disaster or any derailment of this, the first thing you've got to do is get all of the video from the news organizations, get affidavits under 901 to lay the foundation, and they're authentic. So what we did is we played this video, and it's a shocking video. One of the reasons why we played it particularly is the case that we were trying was, and I'm just going to pause it right here as I did a trial, my client was in this Ford F-150 at the time of the derailment. Okay. So as much as people like to do animations today, and you have high impact, incredible demonstrations, nothing is stronger than if you've got great real video or you've got great pictures. Because when you look at it and you want to talk about it, or you have an animation of the train car, you know, being on the vehicle, and it's an animation, it's a lot more powerful to show the video and then pause it for them to see the train on the video, right? So it's something that I've recommended that we used. And what I did in my closing is I played this video, and then I stopped it in my closing and talked about what it was like for my guy to be stuck in the truck for 25 minutes. And the jury just had the truck in front of them at all times. So what we also did next was we tried to incorporate the position of the vehicles with photographs and with animation to explain what these people went through. When we tried the other case, we had an actual passenger of the train. So we had to explain how this mess of cars got where they were at. So we took the aerial view, we placed the numbers of the cars, we then inserted it over the aerial image, and then we created an animation to show how the derailment actually occurred and the placement of the cars. so we could actually get a better view of how what happened. This is how you can take multiple forms of media and incorporate it into one demonstrative. The younger jurors love this. You know, we had a jury that kind of spanned from mid 60s down to a 23-year-old tech guy. They all love this. So we find it to be pretty effective. At least I found it to be effective. Again, the most common video file, I've listed them here. Again, the VCL or VLC player is probably one of the best modalities to use. I've kind of listed them here. I know we're going to post this on the website later, George. Otherwise, if you guys have any questions, I've tried to leave a little bit of time. If I move too fast, I apologize. But I appreciate your time and effort listening to me.
Sean, if I can add something in there too, there are some things technology-wise that I think are evolving going forward, and that's 3D modeling. I know there's been some airline cases where you can't really wheel in a jet engine into a courtroom, but you can build a spec, a 3D model of that. And so I think that might be something for consideration, the right approach to it. And we talked about this too, about the Hoyer lift and things of that nature. Is how do you get a sense of what it's like to be the plaintiff at that point? And you know, we've mounted Hoyer or mounted cameras on the people as far as watching them go through what is actually happening to them. It's a firsthand view of that as opposed to a third hand. You know, we're kind of watching it passively. So just some other things to consider if you're putting together a strategy for that.
Yeah, there's a lot of software that models how passengers react in accidents. And I just saw it done for an air crash case where they modeled what the passengers were going through during the crash. It's just remarkably effective in showing the terror that the passengers went through.
You know, and I think what Doug's also talking about, where you're seeing a lot of people use, is they're putting, you know, if you've got someone who is incredibly disabled or going through a very tough rehabilitation, they're putting a GoPro on their body and going through all the steps of what their day is like, which is a true day in the life. I'm wearing a this is me cleaning myself. This is me looking at my legs that are now gone for 24 hours. It's incredibly powerful. The one thing I heard back on that, we tried to use that once, is it depending on it made some jurors kind of feel like sick or uncomfortable or something like that. So if you're doing the GoPro on a client, it's like anything else. Timing is everything, and focusing on what is truly important is everything. And use it, you know, I don't want to say sparingly, but effectively, right? You know, oftentimes we struggle every day with using video. And George, I didn't bring this up, but maybe it's something you want to talk about, is using video at trial can be very effective and important, but deciding what video not to use at trial is also important. Here in Amtrak 501, we had day in the lives of both of our people. And since I was trying the cases together, one day in the life was just terrible. It was terrible. And so I scratched it. And what it made me do is also scratch the other day in the life, because I didn't want to focus one person's injuries more on the other. And then in closing, I asked for the exact same amount for both. One was a brain injury, one was a physical injury. And the jury came back, you know, the brain injury got, I think, 9, and the physical injury got 7. But then they gave $2 million to the wife for a loss of consortium for the injury. So they both gave $9 million. And I will tell you, we debated for a long time as relates to whether or not to put in that day in the life, but it just wasn't good. And so the smart decision was not to use it. And we looked at it and we did some mocks, and the mocks didn't come up positive on the day in the life. So it was an important thing that we did not use it. So as much as using technology is important in the courtroom, that you want to use video, you have to be judicial about it to know what not to use, which is just as important.
Sean, would you stop sharing?
Yeah, absolutely. You didn't want my logo and my contact information up any longer. Is that what you're saying?
Sean, I have a question.
I've been waiting for this for about 40 minutes.
For about 20 years, Sean, for about 20 years since law school.
Yes, I'll marry you. It's fine.
It's too late. So I think for cases not involving, the brilliance of being able to see all these trains collide to one another, and more of a typical case that some of us might see. For example, in a case that I had, I'm just looking for ideas from you to pick your brain, and of course put you on the spot because we love that.
Yeah, thank you.
So I was fortunate enough that I had some treaters in a shoulder, full thickness rotator cuff, a massive tear of a client, and that I tried down south against State Farm, and I was fortunate enough to come across a video that showed like a dislocation, how a shoulder dislocates, because I wanted it to just not go in passing that a dislocation is something that's serious. My client was handicapped, so she only had the use of her arms. And then I also had a video that kind of showed what it means to repair a massive rotator cuff injury, like a massive tear. So but I was lucky because I had a treater who would work with me, and I said, can you agree with me that this is going to be something that's going to be helpful for them to see?
Yeah.
And then I showed it to him and said, does this accurately portray what a dislocation of the sort looks like, yada, yada. And I did the same thing for the surgeon. And that's the way that we got it in. Are there other ways that you think that we could use those because it kind of brings, if there's not other videos you have of a body cam or of a, something where it's not a train that's being watched collapsing into, over and over again. Do you see use for that to kind of bring in that CSI aspect of things? And is there a better way than the way that I just described than to have this, this treater who's, thank God, was, friendly and willing to work with me on this?
Well, I mean, I think to get videos in and demonstratives like that you pull out, I mean, you just need to lay the foundation through a demonstrative purpose, right? You're not looking at substantive evidence, right? So as long as they'll testify, yes, you've reviewed it as accurate representation, do you think it will assist the jury? You can lock it in. I mean, so if you've got treaters that are willing to play ball, that's great. I mean, so what I've typically done in the past, it's kind of what you've done, is if I have a major catastrophic injury and I'm using medical art, I will have it done. I will have someone, this is what I've done is MetaVisuals is I've hired them, and on larger catastrophic cases, I've had them put it together based off of the op report. And then I send it to the treater and I say, will you make edits? Or what I've done is in the treater's dep is I've given it to them and I said, is this accurate? No. Well, there are changes you would make, and I have them make the changes in the dep. And I go, do you think that would assist people? And I lay the foundation in the depth. So I've done that numerous times. I had a case out in McHenry County that sold for $5.5 million, motorcycle case. And I had MetaVisuals do, and what I did is I put this is what I would tell you to do is if there's a scope picture or a ultrasound or an x-ray, I put that on one half of the sheet and I do the demonstrative on the other half of the sheet. That's how I do it, so they can link it up. Typically, and this is one of the things that you have to do, is if you've got a treater, when you order the medical records, you got to make sure you get the scope pictures, the striker pictures. And oftentimes they'll send it to you in black and white on they're 8 on a sheet. You've got to say, no, I want the actual film. And so that's how I would do it, is I would bring that with them and lay the foundation that way. If you have any procedure where they're scoping a shoulder, you should make sure before you take that depth that you have those, depending on whatever device that they're using. I mean, I know like if you're at CDH or whatever else, it's all striker, right? It's all the scopes for that. And ask it specifically. But what I do is that way, it sounds like you took the treater's depths afterwards, and then you contacted them for the trial purposes. So that, and maybe I'm wrong.
Actually, believe it or not, the defense did not take any treater depths. So it was just like old school, where I got to go in and not know what the heck most people were going to say until I.
Hey.
It went well. but
It's a State Farm's peril. It's a State Farm's peril.
You know, it's so much fun to hear you kids talk about old school.
well,
Right,
you know, I used
right,
to know it.
Marshall?
You know, and obviously this goes back to what I was saying before. You know, I'm now my own firm. My budget is a little bit different than it used to be. So instead of getting meta visuals to do it, here I cut in. If I've got a fracture and I've got hardware that I can see, what I do is I cut and paste that out. I put it in a PowerPoint deck, and then I get something from the internet similar, or if I purchase something, put it next to it, and I take it to the treater. And you lay the
agree.
foundation that way. So
I love it. I love it. I love animations. I love using animations when I have those cases, and especially explaining things. But when it's something so simple as a shoulder dislocation, or something as simple as, you know, like, to me, I didn't need somebody to specially design something like that for a shoulder dislocation that becomes a surgery, you know?
and I don't understand why people, I mean, here with DICOM right now, I mean, if you have a fracture and you can see the hardware, I don't do any models for that. I don't know why. I would definitely just, I mean, when you see a fracture and you see the white hardware there, it's incredibly powerful. You should just use that. Keep it simple, stupid, right?
You know, one thing that is overlooked is that all of this information should be ready for for motions in limine and pretrials, so that everything is disclosed in advance, so that you don't fumble through everything or hear all the objections to everything as you go through. We had a trial where the judge says, "Oh no, we're going to deal with all the motions in limine and everything else on the fly." It killed the case. It just disrupted the flow of the case. The jurors got mad. So it has to be done pre-trial. Sean,
Yes.
thank you.
Thank you, George. Appreciate it.
Thank you. Here's where you get credit. If you want credit, send an email to this email address. The RE is thank you, NWSBA. Include your full name and your ARDC number, and you'll get credit. And with that, I'm going to stop sharing. I'm also going to stop recording.